Hey guys, I'm here at the courthouse, and who do I see? Jehovah's Witnesses. You just can't get away from them. Jehovah's Witnesses. Testigos de Jehovah. See? You guys speak English, right? Have you guys heard of the Australian Royal Commission on child sex abuse? No? They did an investigation into the Jehovah's Witnesses. They found over 1,006 cases of child molestation. Not one was reported to the police. Isn't that something? And the reason why that happens is because of this book that belongs only to the elders. It says in here that a child must have 2 or 3 witnesses before they'll do anything. Most kids never have any witness, right? So it's swept under the rug. This is the reason I'm at the courthouse, to fight against the Watchtower. You need to research your own religion, seriously. Google the Australian Royal Commission. Once you see what happened over there, you'll start asking questions. And you should, you're young. I wasted 35 years in that religion. Open your eyes. That's him with the suit. Standing toward the back. On the left, holding the phone in his left hand. Yeah. So he has a couple of witnesses or whatever. Yeah, that's him, the black guy.
All right.
Okay.
Pero, ¿qué?
Yeah.
Hay una y hay otra. So, es que ya pues, si la guardas, no le digo de qué le pasa a mi cuerpo. Que no salga de ley.
All right, my lawyer is about to serve the plaintiff, Philip Ingram. You've been served, fool. Seriously, I've never met that guy. For him to serve me is really ridiculous. Wow. All right. So here we are. Wish me luck. Hopefully everything goes, smoothly and by plan. See you guys on the other side.
We just push on by. It's funny how hard we try. Take a moment to relax before you do anything rash. Don't you wanna know me? Be a friend of mine. I'll share some wisdom with you. Don't you ever get lonely from time to time. Don't let the system get you down.
Big city life, we try to get by. Pressure not ease up no matter what me try. Big city life, in my heart have no base. And right now Babylon get on me case. Big city life, try to get by. Pressure not ease up no matter what me try. Big city life, my heart have no base. And right now Babylon get on me case.
So this is Philip Ingram's declaration. It says, my first encounter with Adrian was in October 2016 when he came to our Kingdumb Hall and asked to speak with an elder. I grabbed Jonathan Worcester to see what this was about. At first, we thought he was an interested person, and I asked his name, I realized that I knew his family, who are all Jehovah's Witnesses. Woohoo! We invited Adrian into the Kingdom Hall, and he did not want to come in. Really now. In the course of our discussion, we found out that Adrian had been baptized as one of Jehovah's Witnesses, but had not associated himself with Jehovah's Witnesses for quite some time. My next encounter with Adrian was in November 2016 when he proceeded to give us a letter of annulment, letting us know that he no longer wanted to be one of Jehovah's wickedness. We let him know that there is no such thing as a letter of annulment. No, no, no. He mentioned to us that if he was announced as no longer being one of Jehovah's Witnesses, he would sue us. At that point, I accepted the letter and left the conversation. There were other times when Adrian came to our Kingdom Hall and caused a commotion, and the doors needed to be locked and the police were called. Adrian has posted videos of him sneaking into our restroom and vandalizing it, as well as disturbing our meetings. There are videos of him shouting at our members and him having to be ushered out of the premises. There is a real threat of imminent harm which Adrian has publicly made on his social media to take place at our memorial service, boo-hoo-hoo, commemorating the death of Jesus Christ, our Black Mass, which takes place at our Kingdom Hall in 3 days, March 31st, 2018. One of our elders, Chad Hitler, let's just say, spoke with one of the detectives who had come out to our Kingdom Hall location in response to a call when Adrian did what he calls on his social media, crashing the Kingdom Hall. The detective mentioned that in her view, she felt that this was escalating to the point where it could be considered a hate crime against Jehovah's wickedness. Adrian has now caused disturbances beyond our Kingdom Hall. He has gone to many Kingdom Halls in the San Fernando Valley, also in Los Angeles and Santa Monica area, disrupting the public meetings and videotaping them in the process and then posting them on YouTube. He has also gone to where many of Jehovah's Witnesses are preaching publicly with a cart and has caused public disturbances with them as well. He yells profanity. He curses at people at our Kingdom Hall. He gives us the finger. And since our first meeting in October 2016, Adrian's conduct has escalated to the point where many of the members, their children, and the women, and especially the elderly, are in fear of their lives. Wowzer. If you guys were really in fear of your lives, why is it that only males were on the TRO? That's what I would like to know. 24 are females. Apparently only the brothers are in fear of their lives, not the sisters. At our Kingdom Hall, we set up a table for some of the elderly ones in our congregation that can't get out in the ministry as much. On at least 2 occasions, as we were setting up the table for some of our elderly friends, Adrian was out there cursing and yelling to the point where we needed to remove the table so that the elderly would be protected. Now, instead of enjoying our meetings, boring, I and Jonathan Worcester, Chad Hitler, and the other members of our congregation sit in the Kingdom Hall in fear that at any moment Adrian is going to rush our stage, hijack our meetings, frightening our children, women, and elderly, using loud, foul, and aggressive language, and perhaps engaging in some violent activity. We have increased our security cameras around the premises. We've also put a peephole on the door, and we now lock our doors after the meetings start with a couple of attendants to monitor the door. We don't want to use the restrooms in our Kingdom Halls and find that they have been vandalized by Adrian. Adrian has publicly threatened future attacks on our Kingdom Hall, and I've put together a brief compilation of Adrian's social media evidencing a reasonable probability of imminent future harm. And my request is that this restraining order becomes permanent. I am not trying to bring any harm to or on Adrian. All I'm asking for is an order to be in place so that I and the other members of our congregation can come to our place of worship without fear of our peace being disrupted by someone such as Adrian, whose conduct is escalating to the point of imminent violence. Thank you, Your Honor. I declare under penalty of perjury that the above is true and correct to the best of my knowledge. Executed this 23rd day of March 2018 in Reseda, California. Philip Ingram. So here we have my lawyer's response to Philip Ingram's complaint or request for a TRO. It says, to all parties and their attorneys of record, Petitioner Philip Ingram's request for a civil harassment restraining order against respondent Adrian fails to provide clear and convincing evidence of a credible threat of violence or harassment towards petitioner. California Code of Civil Procedure Section 527.6 is not met. California Code of Civil Procedure CCP Section 527.6 states that a person who has suffered harassment as defined in subdivision B may seek a temporary restraining order and an order after hearing prohibiting harassment as provided in this section. In order to obtain a restraining order, the petitioner must provide clear and convincing evidence that unlawful harassment exists. For purposes of CCP Section 527.6, harassment is defined as unlawful violence, a credible threat of violence, or a knowing and willful course of conduct directed at a specific person that seriously alarms, annoys, or harasses the person, and that serves no legitimate purpose. The course of conduct must be that which would cause a reasonable person to suffer substantial emotional distress and must actually cause substantial emotional distress to the petitioner. Further, CCP Section 527.6 defines credible threat of violence as a knowing and willful statement of course of conduct that would place a reasonable person in fear for his or her safety to the safety of his or her immediate family, and that serves no legitimate purpose. In the case at bar, petitioner presents no evidence that there is any harassment committed towards petitioner. The restraining order contains instances where respondent has interacted with congregation members. The only specific instance where petitioner mentions an interaction with respondent occurred on November 13, 2016, exactly 500 days from the date of the hearing, or 1 year, 4 months, and 14 days. The facts alleged in the temporary restraining order fail to identify conduct directed specifically towards petitioner that would warrant clear and convincing evidence sufficient to justify the court's discretionary authority to grant a restraining order against respondent. Further, petitioner's temporary restraining order lacks facts showing that he has directly experienced harassment. Further, the facts, as alleged, do not point to conduct at a specific person, but rather congregation members of Kingdom Hall of Jehovah's Witnesses, located at 23262 Avenue San Luis, Woodland Hills, California 91364. Thus, petitioner's request for a temporary restraining order lacks clear and convincing evidence of unlawful harassment directed towards petitioner to warrant a restraining order. Assuming that the conduct annoys petitioner, respondent's conduct serves a legitimate purpose because respondent is focused on informing the community and the Jehovah's Witnesses community that Jehovah's Witnesses allow child abuse to go unreported based on their views. As a former member who was subjected to child abuse, respondent seeks to convince the community that members of the Jehovah's Witnesses are allowing child abuse to go unreported. Petitioner's restraining order lacks sufficient facts showing an immediate danger. To obtain a restraining order, a petitioner's affidavit must show reasonable proof that the petitioner has suffered unlawful violence or a credible threat of violence by the respondent, and that great or irreparable harm would result to the petitioner. Scripps Health v. Martin, 1999. Here, petitioner fails to identify sufficient facts to support their argument that great or irreparable harm will result if respondent is not restrained. Petitioner's request itself contains broad, conclusory statements alleging that respondent has harassed, trespassed, and physically intimidated congregation members from late 2017 to 2018. Petitioner fails to point out the specific dates of when the conduct allegedly occurred and what happened during such date. Based on the videos that petitioner mentioned in its restraining order request, respondent has not committed unlawful conduct or violent acts towards petitioner. Similarly, there are no facts provided by petitioner in his restraining order showing that petitioner was a victim or threatened victim of violence of any sort. Thomas v. Quintero, 2005. Nor does petitioner present any evidence that he was the victim of a knowing and willful course of conduct that seriously alarmed, annoyed, or harassed him, which served no legitimate purpose. Without facts showing that petitioner will suffer irreparable harm if the restraining order is not granted, the court must therefore deny petitioner's restraining order. Protesting in a public street is a traditional public forum and thereby protected under the First Amendment. Individual speakers enjoy First Amendment protection when they protest on public street, which is undoubtedly a traditional public forum. Intel Corp versus Hamidi, 2003. Public streets are places that by long tradition has been used by the public at large for free exchange of ideas. Clark versus Burleigh, 1992. Here, respondent has protested on a public street just outside the fence of Kingdumb Hall. Since the sidewalk is not the property of Kingdumb Hall, respondent has a First Amendment right to protest there because he is protesting in a location that is considered a traditional public forum. Thus, the court must respectfully deny the restraining order because respondent has a First Amendment right to protest on the sidewalk directly adjacent to Kingdumb Hall. Respondent's conduct arises out of public concern in connection with an issue of public interest. There is no clear-cut definition of an issue of public interest. However, there are guiding principles that help determine what constitutes an issue of public interest. First, public interest does not equate with mere curiosity. Second, a matter of public interest should be something of concern to a substantial number of people. A matter of concern to the speaker and a relatively small specific audience is not a matter of public interest. Third, there should be some degree of closeness between the challenged statements and the asserted public interest. Fourth, the focus of the speaker's conduct should be the public interest rather than a mere effort to gather ammunition for another round of private controversy. Here, respondent is protesting an issue of public interest. First, investigation into child abuse gone unreported by Jehovah's Witnesses is not of mere curiosity. Second, child abuse concerns a substantial number of people and not a small specific audience. Third, there is a high degree of closeness between respondent's conduct and the asserted public interest because respondent has witnessed how Jehovah's Witnesses quail any attempt of reporting child abuse committed by Jehovah's Witnesses. As a result of this, there are many instances of child abuse that go unreported, which thereby allow Jehovah's Witness members to continue to commit acts of child abuse with ease. Fourth, respondent's focus is in the public interest because he seeks to confront child abuse committed by Jehovah's Witness members and to hold them accountable for their actions. Thus, there are sufficient facts showing that respondent's conduct constitutes an issue of public interest and is thereby protected by the First Amendment. Conclusion:
Based on the foregoing, we respectfully request that the court deny petitioner's request for a civil restraining order because it fails to state sufficient facts to warrant a restraining order against respondent. Further, respondent's conduct is also protected by the First Amendment.
Soon our work is done. All of us one by one. Still we live our lives as if all this stuff survives. Don't you wanna know me? Be a friend of mine. I'll share some wisdom with you. Don't you ever get lonely from time to time. Don't let the system get you down.
The lane drifts across the seas and the oceans. A permanent itinerant is what I've chosen. I find myself in a big city prison, arisen from the vision of mankind, designed to keep me discreetly, neatly in the corner. You find me with the flora and the fauna and the hardship. Backyard is where my heart is. Still I find it hard to depart this big city life.